Hello and welcome to yet another episode of Courts This Week. First up in the bulletin, the Supreme Court on Tuesday agreed to hear the petition on Section 377 and referred the matter to constitutional bench of 5 judges. Curative petition, which was filed seeking to decriminalize LGBT sex relations, was heard in an open court. Though the constitutional bench is yet to be formed, which will decide further if this petition is worth a hearing, the LGBT community has welcomed the Supreme Court's decision, saying it's a step forward. The Supreme Court on Tuesday referred the petition over Section 377 of the Indian Penal Code, which seeks to legalize gay sex, to a 5-judge constitutional bench. An apex court bench headed by Chief Justice T.S. Thakur referred the curative petition to the 5-judge bench as senior counsel Kapil Sibal said that the issue involved a question of far-reaching constitutional importance and must be heard by a 5-judge bench. The bench said that the larger bench would be constituted in the future. The bench was told that there were 8 curative petitions seeking re-examination of the order on the review petition and the 11th December 2013 judgment by which the Delhi High Court verdict decriminalizing Section 377 was set aside.
उन्होंने कहा कि ये जो क्यूरेटिव पिटिशन है जो 3 जज सुन रहे हैं उनके बजाय वो कॉन्स्टिट्यूशनल संवैधानिक बेंच को भेजेंगे जिनके सदस्य होंगे 5 जज। तो वो अभी हो गया है कि वो अभी जो क्यूरेटिव पिटिशन है अभी 5 जज से सुनवाई होगी।
The bench was also informed that the churches of Northern India and All Indian Muslim Personal Law Board were against decriminalizing homosexuality. The bench was further informed that the High Court judgment was not challenged by the centre, which had left it for the apex court to take a call on the issue. However, when the High Court judgment was overturned by the Supreme Court, the centre had preferred the review petition, which was dismissed. The bench said such an important issue needs to go to a constitution bench of 5 judges. A curative petition is the last judicial resort available for redressal of grievances in court, which is normally decided by judges in chamber. But this matter was made an exception. The Supreme Court has told the BCCI to respect Lodha panel report. CJI bench gives board 4 weeks to respond on implementation of committee's recommendations for restructuring of the cricket body. The Supreme Court on Thursday suggested that the Board of Control for Cricket in India, BCCI, fully accept the recommendation of the Justice Lodha Committee on the structural reforms of the apex cricketing body. A bench of Justice T.S. Thakur and Justice Fakir Mohammad Ibrahim Kalifullah told the BCCI that Justice Lodha Committee has given viable rational solutions. You take a realistic view of the matter and act according to the recommendations. Impressing upon the report's significance, the apex court told senior counsel Shekhar Nafade, appearing for the BCCI, that the report deserves respect as it is given by the most competent and well-meaning members of the legal fraternity. It may affect some people who are holding positions, but any transition has to have its problems. The court said, as Nafade sought to project the difficulties that the apex cricketing body was encountering with the recommendations. Not missing on apparent reservations on the part of the BCCI, the court made it clear that it would not appreciate any suitability assessment of the recommendations by the cricketing body. The matter would come up for further hearing on 3rd March. The Maharashtra government told the Supreme Court that there was nothing more perverse than the Bombay High Court judgment acquitting actor Salman Khan in the 2002 hit-and-run case, despite overwhelming evidence that he was drunk and driving the heavy-duty SUV.
The apex court on Friday posted the 2002 Salman Khan hit-and-run case for further hearing on February 12. State government submitted before the court that the actor Salman Khan's defense was completely unbelievable, that it was not him and their family driver, Ashok Singh, who drove the Toyota Land Cruiser at the time of the incident. Attorney General Mukul Rohtgi, arguing for the state, submitted that the High Court chose to discard the versions of the police and injured persons, pointing to Mr. Khan as the person behind the wheel of the vehicle. Mr. Rohtgi said alcohol content in the blood samples taken from Mr. Khan even after 12 hours from the incident registered double the permissible limits. The bench said it would hear the government in detail on the evidence before admitting the case, as it was an appeal against acquittal.
In case related to Arunachal Pradesh's long-standing political career, Congress had appealed against the precedent rule in Arunachal Pradesh, regarding which Supreme Court had sent the notification to Governor earlier, which has now been recalled. The court accepted the centre's argument that Governor J.P. Rajkhowa enjoys constitutional immunity.
Supreme Court on Monday recalled the notice it had issued last week to the Governor of Arunachal Pradesh. This was the second instance in a span of 2 weeks when the apex court had recalled its orders. Admitting that it had committed a mistake by issuing a notice to the Arunachal Pradesh governor, a 5-judge constitutional bench of the Supreme Court recalled the order, holding that governors and the president enjoy certain constitutional immunity. The bench is hearing a batch of petitions challenging the imposition of president's rule in the state and the governor's decision to convene the assembly without the advice of Council of Ministers. The bench, headed by Justice J.S. Keher, ordered the centre to furnish crucial documents seized from former Chief Minister Nabam Tuki's office by Friday. It, however, did not issue any directions on Tuki's plea to order restoration of the pre-president's rule situation in the state.
भारत के संविधान की धारा 361 के अंतर्गत सुप्रीम कोर्ट से या किसी न्यायालय से भी राज्यपाल और राष्ट्रपति उनके द्वारा जो भी कार्य किए जाते हैं उन पर नोटिस नहीं इशू हो सकता है, उनको कोर्ट में समन नहीं किया जा सकता है। इस पर कॉन्स्टिट्यूशन बेंच ने आर्गूमेंट सुनने के बाद जो अभी याचिकाएं राष्ट्रपति राज लागू करने को चुनौती देने वाली याचिकाएं हैं, उनमें से राज्यपाल से जो नोटिस इशू किया था उसको विड्रॉ कर लिया है और जो बाकी भी याचिकाएं हैं उनमें राज्यपाल को नोटिस इशू ना करने का निर्णय किया है।
The bench acknowledged Attorney General Mukul Rohtagi's submission that no notice could be issued to the governor or the president under Article 361 of the Constitution, which gives immunity to them. They are not answerable to the court for acts done in discharge of their duties. While the bench recalled its notice, it said the governor was at liberty to file his response if he desired to do so on his own. Immediately after the recall order, senior advocates Fali Nariman, Kapil Sibal and Rajiv Dhawan urged the bench to restore the status before President's rule was imposed, a plea the court declined.
In a bid to release its jailed chairman Subrat Roy, the Sahara Group has now sought permission from the Supreme Court to sell its shares in Formula One team. The group has to arrange Rs 36,000 crores for making the payment in the SEBI Sahara account for refunding the money to its investors.
The Sahara Group came up with a fresh proposal to secure the release of Subrat Roy, who has been in jail since March 2014. As part of its efforts to raise funds for the release of Subrat Roy, Sahara Group has sought Supreme Court's permission to sell its shares in the Force India Formula One team. Sahara's counsel, senior advocate Kapil Sibal, told a bench of Chief Justice T.S. Thakur and Justices A.R. Dave and A.R. Sikri that the group has decided to sell its stake in the Formula One team along with Sahara Star Hotel in Mumbai and 4 small aircrafts. The company claimed that selling these would fetch around 3,000 crores. The group currently owns 42.5% shares in the team and the same amount of shares are with businessman Vijay Mallya. In June 2015, the Supreme Court had asked the Sahara Group to arrange 5,000 crore rupees in cash and an equal amount in bank guarantee for the release of its chief. Sahara chief Roy was arrested in 2014 after the group failed to comply with the court order to refund money raised from millions of small investors by selling them bonds, later ruled to be illegal. The group has been trying to raise funds since Roy's arrest, but has failed in several past bids to comply with the top court's order to return Rs 360 billion to investors in the banned bond plan.
It's time for a short break. We'll be back with more news from courts. Stay tuned.